Thank you and welcome to the Cozy Web Ed webinar. Today's topic is creating your legal toolbox, tips and tools for small business owners, and will be presented by Sharon Torek. Before we get started, I would like to take a moment to go over a few housekeeping items. My name is Adina Magda, and I will be the webinar organizer for today. We want to make sure today's presentation is extremely valuable for you. So we ask that you submit all your questions by clicking on the question button in the control panel and typing in your question. Your question is only visible to me. I will collect all submitted questions and we will do a Q&A with Sharon at the end of her presentation. Now for the main event. I would like to introduce Sharon Torek. Sharon Torek is the principal of Torek Law, a national intellectual property and marketing law firm focused on helping businesses protect and monetize their intellectual capital. Torek is also a frequent speaker to business organizations, professional organizations, and businesses on intellectual property legal issues. Her speaking experiences include presentations for the Cozy Small Business Convention, and actually this webinar started because her workshop at the Small Business Convention this past year was so successful we invited her back to do this webinar. She also spoke at Ad Age Small Agency Conference, Content Marketing World, and Agency Management Institute conferences. Sharon is also the publisher of the marketing industry legal blog, Legal and Creative, and is the creator of Legal and Creative Agency Protection System, a legal education and support tool for marketing ad firms. So she's going to share her contact information at the end, so if you have any questions, Sharon is more than happy to answer any of those at the end. So you'll see her contact information in the last slide. Without further ado, I would like to hand it over to Sharon.
Thank you, Adina. Good morning, everybody, and thank you also to Cozy for having me back. I'm going to make sure that, let's see, are we all good on the screen here, Adina, all nice and clear?
I need you to accept what I sent you.
Okay.
You got it. There you go. You're perfect now.
Okay. Great. Sorry, everybody. All right. Let's get started without further ado. And thanks again to Cozy for asking me back and for letting me share some of our content on how to build your small business legal toolkit. This presentation got started because we found that most entrepreneurial companies sort of address their legal issues like putting out fires. And what we've learned with working with a lot of small companies is that if you have some tools in your kit in advance and sort of look at your legal issues more proactively and have these things at the ready, it definitely reduces your sense of urgency, emergency, and your costs in the long run. So what we're going to talk about today are some ways to gradually build your small business legal toolkit, and I will acknowledge that some of these are going to sound like great ways to spend money on legal fees, but I think if you look at them as sort of a to-do list and phase them in over time, you will find that over the long run, your preparedness is going to save you time, save you money in the long run. So let's just quickly review the goals for the presentation over the next 60 minutes or so, and hopefully we will leave quite a bit of time for your questions on any or all of these topics. So we will review the top tips that I want to share with you and the related legal tools in these three areas. Each of these could be an entire day workshop for small business owners, and we don't have that kind of time today, obviously, but we're going to hit some high points about legal tools that will be helpful to you in the area of your corporate structure and your contracts with your clients, with your business partners, with your vendors. We will touch briefly on the legal tools that small companies need to have in their kit related to employment matters. And then we'll round it out with a discussion about the top tools that you ought to consider having in place in protecting your intellectual property, which is a topic near and dear to my heart because it's where I spend most of my time. And I also find that most small businesses tend to undervalue the amount of intellectual capital they truly have in their companies. And it's probably, for most of you on the line today, your most significant asset. So whatever we can do to help you protect it is a win for everybody. And then in the Q&A section, we'll sort of discuss where small businesses might get it wrong or what might need the most help, or anything else that you send questions along to Adina about. All right, so let's get started. Let's talk first about your business structure as a small company and your relationships as a business. First, let's talk about your format. I think the important thing I'd like you to come away from today's presentation with is the knowledge that if you don't pick a format, a formal organization structure, one will be selected for you, legally and tax-wise, and that's not the result that you want. You want to be thoughtful about whether you decide to establish yourself as a limited liability company, which is probably the most popular option for small, closely held companies because it combines sort of the legal flexibility of either a sole proprietorship or a partnership with that, that limited liability and corporate veil of a corporation. For some companies, though, electing to be a corporation and either subchapter S status for small companies or C Corp status, and these are decisions, S versus C, you want to make in tandem with your accountant. Every business needs a very good business accountant to help them along the way make these choices. And then finally, and this will be the default if you are a single business owner, and that's sole proprietor. And the reason you want to be very thoughtful about reverting to that is because as a sole proprietor, you are going to be personally liable for the obligations of the business. If you don't have an entity in place and that corporate veil in place between you and the rest of the world, you're putting your personal wealth and your other personal assets at risk, which is not a result that we would want for you. If you are in business with somebody else, you will probably be assumed to be a partnership. Again, not as many legal protections with an informal partnership as there would be with two people who form an entity and each own a share of that entity. So your legal tools related to corporate structure are choosing your entity type and then establishing that entity with the Ohio Secretary of State, either by filing articles of incorporation if you are going to be a corp, or your articles of organization for an LLC. And then where I find small business owners mostly get it wrong is that they stop there. They file their paperwork and their statutory agent designation with the Secretary of State, cross that off their list, rub their hands together and say we're good to go. Not quite. What you really need to do is make sure that you are rounding out your corporate documents by preparing bylaws where they're necessary, particularly in the case of a corporation. If you're an LLC, you want to put an operating agreement together that sort of serves as your bylaws. You particularly need that if there are more than one, if there's more than one owner of the business. Your code of regulations, and any corporate resolutions that your legal counsel might recommend to you or that your accountant thinks are important. If you go to a bank to establish a banking relationship as a business, they're going to want to see something more than your certificate from the Secretary of State. They're going to want to see evidence that you have put together the correct corporate structure. And you need to make sure that at least annually, in my view, you're taking a look at these records and making sure that they're up to date and reflecting all the actions that you've taken over the year as a business and that you've authorized them. One of the reasons for forming an entity is that legal veil of protection, and it's easy to lose that legal veil of protection if you don't follow the formalities of a corporation or a limited liability company. So that's the first set of legal tools, are all the documents surrounding forming your business and making sure you maintain them currently. All right, what about your relationships? Let's talk first of all about a situation where you're not a sole proprietor or a solo business owner. You have one or more business partners, one or more fellow shareholders if you're a corporation, one or more members if you're a limited liability company. It is never a good idea to proceed down that road without documents in writing that outline your relationship with one another. Whether it is a buy-sell agreement that indicates the rules of the road about how you would unwind one of you from the business if that was necessary, and how you might consider valuing the share of a departing member of the business if you wanted to buy them out. You need a buy-sell agreement in place to reflect those understandings. Confidentiality and non-disclosure. We particularly find this relevant in the area of intellectual property, for example, but also in the area of restrictive covenants. You don't want to put yourself in a situation where you haven't thought about what would happen if one of your business colleagues or partners separated from the company and started a competing company. You want to think about that, talk about that in advance, and then put together an agreement between the members or owners or partners that reflects what would happen if one of you wanted to separate from the business. Would you be able to compete but not solicit one another's customers? Would you not be able to compete? And if not, for how long would you not be able to compete? And also an agreement to keep the information of the company confidential even after one of you exits the business. So where we find small business owners getting it wrong is sort of maybe if they get over the finish line with documenting their corporate structure, they may not take that next step in putting together a formal agreement with their partners, fellow members, owners, and shareholders. So take the time to do that. If you ever find yourself in a situation where you unexpectedly have a separation in the business, you're going to want to have good, solid documents in place in advance so that nobody's caught by surprise. All right, what about third parties? What about the either freelancers, independent contractors, or vendors that your business relies upon to provide services or make products for your customers, your clients? You want to document your relationships as a business with your suppliers, your vendors. If you have a strategic alliance with another company to provide something, you want those relationships in writing. If you use freelancers, and this is almost every small business these days, small business owners would love to have the flexibility of using somebody on a 1099 basis because of the simplification and because of the perceived cost savings of not withholding taxes. But if you're going to do that, and we'll talk more about this later in the intellectual property section of the presentation, you need to have that relationship reflected in writing. Not only is it important for IP ownership clarity, but the IRS, one of their main factors in determining whether to treat somebody like your employee versus an independent contractor is whether or not you have an agreement in writing with them. So your legal tools are making sure that your relationships with your vendors and suppliers are documented in a contract of some form. Even if it's a purchase order with legal terms and conditions on the document, that may be in many cases sufficient for you. Make sure there are legal terms and conditions there, particularly payment, late payment, etc. With your independent contractors, you should not be engaged with any freelancer without having a written agreement in place before that individual or that other company starts work for your business. And those agreements, in both cases, where it's important, particularly in the independent contractor agreement, should have confidentiality and non-solicitation language. Sometimes you want to make sure you include that language in your vendor or supplier contracts as well, particularly if those vendors or suppliers might also supply some of your competitors in the industry. You want to make sure that if they have access in particular to your client or customer list, they're not sharing that information publicly. Okay? Finally, your customers, your clients. Are you engaging with them just verbally, just by email, just with a handshake? If you are, I would encourage you to stop handling the relationships that way. If you provide a product or a service directly to a consumer, again, at least have an invoice that reflects legal terms and conditions of the sale on a document somewhere. If you are a service firm, you really need a service agreement between you and your customers that indicates fees, costs, what you're agreeing to do for them, when they're agreeing to pay for you, just simple things like that. And I've indicated a few of the top notes here on the slide: work descriptions, payment terms, late payment penalties. I'll say this is, too, as incentive for you. If you ever find yourself in a situation where a customer or a client has not paid you or isn't paying you in a timely manner, and you need to take legal action against them because of that, you are not going to recover the costs or the attorney's fees that you incur to do that unless you have a provision in your contracts that say so. So that in and of itself should be sufficient incentive for you to have agreements in writing, and make sure you include that language. If you want to be able to charge interest for late payments, if you want to be able to recover your costs of collection, your attorney fees, that's all got to be in writing, or no court is going to allow you to recover those things. So good incentive there for making sure you've got good, solid contracts with customers or clients. And this is an area where, you know, you create a document once and it's going to be pretty evergreen. So it's worthwhile to invest the time, energy, money up front to have a good, solid standard agreement now, so that you don't have an unexpected issue later. All right, employment law is, again, an area that we could spend a really long time talking about. I'm going to only do a very shallow deep here today, deep dive, and give you some top notes about things that you want to make sure you are thinking about, maybe a punch list to take to your current legal advisor, or to find one to help you work through. But employment law is very dynamic, very complex, and changes very frequently and very quickly. And so even if you've only got a few employees, my advice to you is to look at your employment documents and build them for the company you want to be versus the one you might be today if you're small. You want something that will accommodate growth so that you're not revisiting them constantly, and something that sort of establishes a structure and a precedent with your current employees, that you regard these relationships seriously. So if you don't have an employee policy and procedure manual, tool number one, you should. And it may feel a little bit like overkill if you are a small company of 2, 3, 5 employees, but it sets the rules for the road, it sets expectations, and it also creates a perception about how you regard your, the professionalism with which you regard your relationships with your employees. It also is the tool that will best serve you if you ever have an employment dispute with an employee who either departs or has issues as an employee working with you. So policy and procedure manual, these don't have to be 100-page documents, but you should have one, and you should have one early, and you should be reviewing it at least annually. Written job descriptions are sometimes very appropriate. I probably wouldn't put this second on the list if I was triaging this list of 4 things here, because these can change, and you may add positions, you may consolidate positions, you may delete positions. But I would take a look every once in a while at your job descriptions and make sure they are up to date. Because if you're in a situation of having to counsel an employee who's not fulfilling their job duties, you want to make sure that your expectations of them are reflected in their job description. You don't want that to come back around and surprise you. Work conduct policies, including, and this is becoming increasingly important, anti-discrimination policies, anti-harassment policies. These should be no tolerance, zero tolerance policies on your behalf as an employer. And then supplemental things like your ability to have the flexibility to drug or alcohol test if you suspect an employee of being inebriated or under the influence while they are working. A policy related to workplace violence and how it will be handled if it becomes an issue. Weapons prohibition. Things like these are things you have to think about on a case-by-case basis, depending upon what kind of business you have, whether you deal with the public, whether your workers are remote or virtual, or actually come to an office or a factory or a store. But at a minimum, you want to start with your policy and procedure manual and then sprinkle in these other things depending upon your circumstances. personnel records. This is something for a small company that can feel a little overwhelming to get a handle on because you can accumulate what seems like a crazy amount of paper even for a small staff. So these are the things that you want to make sure you've always got on file for each of your employees. Obviously your tax withholding forms that are signed by any employee who starts with your company, your I-9 immigration form certifying the immigration or citizenship status of an employee, the original job application and resume that the employee has submitted before they came to work with you. The reason it's important to keep this on file, if an employee has unfortunately misrepresented their experience level or a credential, this is important information to have in their file in case you candidly need it as evidence later. Any records in writing of employee discipline action, you want to make sure those are kept up to date and easily accessible if you need them later. Employee performance evaluations, those are critical as well because they, over time, display a pattern of performance, and you want to make sure you have them accessible. An important thing to the extent you have to have medical information on file about an employee, and those situations candidly should be rare. If you're in an ADA situation where you're expected to make an accommodation for an employee under the law, things like that are good examples of situations where you may need to have some medical information on file. Keep it separate for HIPAA reasons and other reasons from the rest of the employees' personnel records. All right, public postings of certain types of employment laws is required by Ohio law, by federal law. And so this is a list of certain laws, policies, and rules that either your municipal, state, or federal government require that you keep posted in a publicly accessible place, and not public as in your customers or clients, but publicly accessible to all of your staff. Equal Employment Opportunity Commission notices, wage and hour law notices, for example, that poster we've all seen that states the minimum wage requirements, any FMLA requirements and policies that might be impactful on your business, OSHA safety rules and requirements, child labor rules, and if you have a polygraph policy, if you feel that you need to reserve the right to polygraph an employee, you want to have that policy posted publicly. So there are services that make these posters available, and some of them even consolidate the notices on a larger poster. So that's something to look into. But at a minimum, you should be able to get the notices and posters from the government authorities that require them and that require that you post them. All right, everybody who has employees knows that there is some government that will require you to report something at various times throughout the year. So know what those compliance and reporting requirements are for your business. Obviously, you've got to report not only to the IRS, but to the state tax authorities and, in many cases, municipal tax authorities on income. You are required to make your I-9 reports on hiring and periodically. It's not new anymore, but it's recent fairly. There is an Ohio new hire reporting requirement as well that models some of the federal reports that need to be filed. Legal tools here. Make your life easy by being up to date on the forms and reports that are required, and have these forms handy. Have the URLs handy if they are forms that you want to complete online. Have the actual empty reporting forms handy so that you are not reinventing the wheel every time a new hire starts. And designate somebody specific in your organization, even if it needs to be you, who is responsible for the workflow and the reporting requirements. It'll save you a lot of time later if this is consolidated in one place, one department, or with one person, so that no balls get dropped. All right. Dina, I think I'm going to pause there for a moment. If you've got any questions that have been submitted so far.
Yeah, we actually have a few questions. So
Okay.
I'll tell you the first one is, a colleague of mine and I, both single entity LLCs, are launching a joint venture which will be revenue generating and, more importantly, client generating. What is the best type of contract or agreement that we should have in place?
That's an excellent question. My recommendation there would be to put together either a joint venture agreement that would not only discuss the roles and responsibilities of each LLC that will be a party to the joint venture, but also addresses things like how will each party be compensated from the joint venture, who will own the customer relationships in the joint venture, whether it's the company that brings it to the venture or whether you will both own it if the venture dissolves. And then things like confidentiality. If the joint venture is going to create any of its own intellectual property, then you'll want to address that in the agreement. I sometimes see these documents referred to as strategic alliance agreements, but I think in this case where both parties are going to collaborate under a common brand, for example, that probably the joint venture agreement is the most appropriate.
Great. And the second question is, can you recommend any resources for simple service agreements for a sole proprietorship?
I can't, other than to suggest that there are some online services where you can buy contract packages. I think that I'm going to full disclosure here, not a great fan of directing a small business owner to just to the web to find downloadable contracts. I would rather have, frankly, you draw up your own version of a contract and then take it to a lawyer to review and finalize. You know, include all your important information, who the parties are, what the services that you're going to provide, what the costs or fees might be for that service or that product, when the product or service will be provided, and what the penalties might be for late payments or failure to pay. I'd rather sort of have you draw up your own terms and conditions and have a lawyer look at them and finalize them than have you download the wrong form. But if you're inclined to try to take a do-it-yourself approach, I'd simply use one of the internet search engines, and you'll get a list of companies that sell contract forms. The problem is you won't necessarily be able to review them in advance to know whether they're good or appropriate for you. So that's my word of caution there.
Okay. And the next question is, does Sharon know California law too? This one comes from a sole proprietorship with a couple of independent contractors, a very small business, and she's based out in California.
Well, I think that independent contract relationships are pretty universal, state to state. I don't practice in California, but what I will tell you is that the things you want to most cover in an independent contractor relationship are primarily things that relate to federal law. So you want to make sure that you are covering things like ownership of the intellectual property that the independent contractor creates for you, creating a statement that the work they do is a work for hire for your company, making sure you have an affirmative statement in that agreement that that person is an independent contractor, is responsible for reporting their own income, is responsible for paying their own taxes. And again, all the other sorts of things that you would have in an agreement with your customer, except in this case, you're basically in the role of the customer. Like, what exactly is the work you will be engaging them to do for you? When is it going to be due? What are the performance requirements? When can you both terminate? Those sorts of things. It's easier to find, I think, let me put it this way. The sorts of terms and conditions that are needed to be in an independent contract agreement are more standard across the board, state to state, than an employment contract would be. So I think I'll leave it at that. And then
Okay.
follow up with you by email if you have any specific questions. I'd be happy to answer those offline.
Perfect. So another question is, if we get sued for non-performance, wouldn't we have a stronger case if we didn't have a contract?
No. No, I think that it's always beneficial to each party in the relationship to have a contract in writing, and here's why. It sets the expectations up front, and you can learn a lot about either your vendor or your customer, I will say, based upon sort of how they conduct conversations when you're getting a contract signed. If there's inclined to be any red flags about how they're going to be to work with, and this is more business advice than legal advice, it will tell you something about what the relationship's going to be like. So I'm not a big fan of leaving things unstated in writing to give yourself more wiggle room, because I don't think it does. I think ultimately, in a case where there isn't anything in writing, it comes down to one person's word versus another. But that's going to cost both parties money, you know, to establish if it escalates to legal process, which I hope it doesn't. So no, I think the preferred approach and the more effective approach, and actually the most cost-efficient approach, is to put things in writing from both parties' perspectives.
Perfect. And then there's another question that said if you could elaborate a little bit more on and explain the term work for hire.
Sure, I'll be happy to, and we're going to be talking a little bit about this in the next section on intellectual property. So work for hire has become, work for hire is a term that originated in the copyright law, actually, and still exists in copyright law. And candidly, those words are used in a manner that wasn't quite intended by the Copyright Act, but what it means when you see the language work for hire in a contract is that you are engaging some third party who isn't your employee. Remember that, and again, we'll go over this in a second. If somebody is your employee, if they've got a W-9 filled out, if you are compensating them as an employee, you already own the rights to the work that they do within the scope of their job for you. So you don't need a work for hire agreement. You always throw that policy in your manual, but the way the copyright law works, if an employee creates something within the scope of their employment, you automatically own the rights to it. So you don't need work for hire language. But increasingly, as we all know, we're relying on virtual resources, independent contractors, and freelancers. So what work for hire in that context means is I, company A, am engaging you, Mr. or Ms. Freelancer, to do this for me. Create a brochure, build a website, whatever it might be. And that work is a work for hire for my benefit, and I'm going to therefore own all the rights to it, all the copyright, any other intellectual property in that work. It is a work for hire for my benefit. So that's sort of become the conventional and popular way to use the terminology, so we still use it in independent contractor agreements. What it means is it sets the expectation and creates an ownership statement about whatever it is you're engaging the freelancer to do for you. Because as we'll discuss in a second, if you don't have that language or some similar language in your independent contractor agreement, you don't own the rights to the work that that freelancer has done for you, even if you've paid for it. So let that sink in for a second. You don't own the rights, even though you may have paid for it. Copyright, intellectual property rights in general, do not necessarily follow the money, which is really illogical to business people. So I spend a lot of time explaining it to them in my intellectual property practice.
Great, and Sharon, that's it for the questions for now.
Okay.
But
all right, great.
Audience,
so
keep
we'll
asking them.
Yeah. No, these are great conversation starters. So let's talk a little bit about intellectual property. Every small business has some, and every small business owner I talk to undervalues their intellectual property, or they don't realize that they have as much as they do. So let's talk about the types and the legal tools you might consider having in your toolkit to protect. First of all, your brand. Your brand is most likely serves as a trademark. And a trademark is a piece of intellectual property. It is something that you own. It is something that over time, if you build a strong business behind your brand or a great product or service behind your brand, the brand itself becomes valuable as a piece of goodwill, and it can increase the amount of money you charge for your products or services. It can definitely increase the amount of money that your business is worth if you ever want to resell it, or if you have designs on franchising it, for example. Your trademark portfolio will be a huge part of the transaction. So your brand, and the brand not only of your company, but if you've got original and unique product names or service names, or sometimes even process names, those names can also serve as trademarks, and you can end up having a larger portfolio than you might expect. So how do you protect them? The protection starts, I say, before you adopt a brand. You want to make sure that you're taking the time to do a trademark search before you name your company or name your products, to make sure you're not finding any conflicting registrations or brand names out there in the market that could confuse a customer. And if you've cleared that trademark search, then you're going to want to take steps to preserve the rights to that trademark. Most small businesses these days are actually engaged in interstate commerce, which means commerce in more than one state, even if their operations are regional, because they do business online. And if you've got an internet presence, if you ship products outside of Ohio, if you provide services that are accessible online, or you actually go to other states and provide services, you have the basis for potential federal trademark application. I much prefer these. We certainly, and in my earlier years of practice, we did a lot more state trademark applications. That is still a viable way of registering a trademark. If you are truly only a local business that perhaps doesn't sell online, doesn't have designs on doing business beyond the region, you may also apply for a trademark within the state of Ohio. But where you have the basis to, I always advise clients to pursue federal trademark protection. A couple things that I want to fill you in on. There are ways you can start the search process for free on your own. One resource that I would point you to, which is on the slide, and Dina will be happy to send the deck out to anybody who wants it afterwards, uspto.gov. This is the website of the United States Patent and Trademark Office, and it has a search feature, which is called TESS, T-E-S-S. It's a very easy drop-down menu to find. So go to the TESS searching service, plug your terms in. I will caution you that this is a good place to knock a trademark out. For example, if you find something that conflicts, then you can scratch it off your list right away. It's not necessarily trademark clearance. It's also, you may not also get a very clear picture of results because you may get a very long list of them. So you're probably going to need then to, if you haven't knocked your mark out here, then you're probably going to need to go to the next stage, which is to engage a trademark search firm or a trademark lawyer to help you actually conduct a screening search or a full search of your trademark. So those are the primary tools in that case. I want to remind you of a couple of things as well. Finding a really cool domain name is a rare thing these days. It's getting harder and harder for businesses to find a piece of real estate online that matches the brand they want to have and that is also available. If you do find one, remember that finding an available name is not necessarily the same as finding an available trademark. You want to search it both ways. You want to make sure that if you're going to invest money in naming your company or a product or some other offering, that it's not only, it's excellent if you can find the domain name that matches, but what you really want to make sure is that you do your trademark screening and searching, due diligence. The other thing I want to remind people on the line about is that trademarks are category specific. So that even if you find a name out there that sounds very close to yours. If it is in a completely unrelated industry, then you probably don't have a trademark problem, and you may very well be free to adopt it. Trademarks are ownable by category, if you will. So it is possible that I own the same trademark to identify consulting services as someone else uses to sell lawnmowers. Just to give you a crazy example off the top of my head. Trademarks are category specific. So this is where really having some guided assistance is important. Trademarks can be deceptively easy looking to register, but there's a lot of groundwork that you need to make sure you do before you apply, and certainly before you spend money on marketing to put a brand in use. All right, so back now to the intellectual property question that one of our listeners asked earlier. You want to make sure that if you are using anybody, whether it's an individual or a company that does not work for you as an employee, to create anything for you, whether it's photography, a mobile application, website design, computer programs, whatever, you've got to have an agreement that includes a provision in writing about your ownership of that intellectual property. And I put this in big red letters for a reason on the slide here. If you don't have a writing, you don't own the rights. All right, so if you come away from this with nothing but that related to intellectual property, and I stress it so hard because we're all working virtually these days. Our new work model is very different than it used to be, and we're teaming virtually all the time. And it is very easy in a fast-moving situation to sort of treat this as an afterthought. I don't want you to do that. I'd like you to have a solid work-for-hire and independent contractor agreement in place that's evergreen and can be used for all your freelancers or third parties so that you don't have to recreate it each time. If you haven't done that, and I know some of you haven't or won't, something you can do after the fact, if you still have a relationship with the freelancer or the contractor, is to get an intellectual property rights assignment from that person or organization. That's a document that assigns the rights in the work that they've created for you to you, acknowledges that you've paid them, and transfers their rights to you. This is important so that if you're ever in a situation of having to either sell your business or sell whatever the work was, you've got a clear chain of title to that work. So best practice, have an agreement up front. Second to best is try to get an assignment after the fact before the relationship between you and the freelancer concludes or dissolves. All right, let's talk about trade secrets. I think there's a lot of mystique around what a trade secret is and isn't, and what a small business owner has to do to protect the information that they consider a trade secret from the outside world. Every business has proprietary information. Whether it is your customer list, it's probably one of the most common types of intellectual property every business has, or a secret formula, or a proprietary product. Every business has proprietary information. Not all of that information, though, is a trade secret. A trade secret is a very specific kind of intellectual property that has economic value to your business and that has value because it is confidential and known only to you. So let's let that sink in for a second. It's got to have economic value to your company, and it's got to be kept secret. So some easy things to do internally are to really only give the people who absolutely need access to the information access to the information. That's one measure. You used to be able to put information that was a trade secret in a locked file cabinet and say that's our security measure and everything in there is a secret and it's a trade secret and I'm the only one who has the keys to it. Well, we know the world doesn't work that way anymore. Everything's accessed electronically. We're all using the cloud to store things. So you need to be careful about who you're giving the keys to the castle to in terms of access to data and information. And it's got to be information that, let's say, if it was in the hands of your competitor, might be damaging to your business. So, therefore, if you've got your client list published on your website, it's not a trade secret. And if either a former employee who doesn't have a non-compete pursues those customers, or if your competitor independently pursues them, they're not violating your trade secrets. So if you consider your customer identities secret, don't publish them. You have to make a business decision about which is more important. One trade secret that I think small business owners tend to overlook as well is if you've got a really great vendor resource for something special that you resell to a customer, or a vendor that is your outside job shop or your third-party production partner or something, and you would really prefer that your competitors not know about that vendor, or if you have proprietary pricing from that vendor that you wouldn't want your competitors to know about. Those are examples of things that could also be trade secrets if you maintain them in the proper way. If you need to disclose information that you think could be a trade secret to somebody outside your company, you want to make sure you have a non-disclosure agreement in place with that third party. For example, if you sell a product and you use a third party to produce that product, you're going to want to have a non-disclosure agreement with that third party. In the case of the joint venture question that we had from one of our listeners a couple of minutes ago, if each of you are going to be bringing potential client relationships into the joint venture, then you want a non-disclosure agreement reflected in that joint venture agreement about the identities of those customers or clients. All right, so some legal tools here. First of all, a confidentiality policy internally. You can create a policy that's a standalone. You can also incorporate this policy into your employee policy and procedure manual. And then having a form non-disclosure / confidentiality agreement at the ready for when you need to interview a potential vendor, partner, third-party resource. In some cases, I recommend that companies have these ready to use with potential freelancers because maybe you want to talk to a freelancer or an independent contractor before you decide to use them on a project. And that requires disclosing some information either about the project or about your company. So having a non-disclosure agreement that you could use for those parties is good practice as well. All right, Adina, I'm going to turn it back over to you to see if you've got any questions sort of about intellectual property of that small company and how to protect it.
Sure, I actually have one question, and it's not too late, audience, if you want to submit a question, just type it in and send it over to me, and I'll read it to Sharon. So the next question is, are there any forms for IP rights assignment? I've hired a firm for marketing and website development and would like to have one of these. Where do I get one?
No forms online that I know of. Our firm does sell a legal toolkit that is sort of industry specific that does contain such a document. I don't know anywhere else online to get one, and we certainly don't sell them as standalone documents. But the best thing to do, I think, is to engage counsel to prepare this one time for you, and then you'll have it, and you can sort of amortize the cost of it over multiple third-party vendors. And again, send me an email if you have a specific need or question, and we might be able to help you with that. But yeah, in case it's not coming through in my answers to the questions, I'm not a huge fan of. I understand the online services that are out there and the need, the need that they're filling. My only concern is that sometimes it's very hard to vet what you're getting before you pay for it. I don't have a problem with, obtaining a packaged solution for sure. Just do some investigating about the resource that's providing it before you spend your money on it. I guess would be my best advice there. And to that questioner, feel free to shoot me an email and I could probably provide you some more specific direction.
Perfect. And then there's just a general question, which I'm definitely going to send out to the group in regards to your services and price estimates, and I know that's based on per job. So to the person that asked that question, I will be sending Sharon's contact information, and you'll be able to reach out to her and contact her one-on-one and get those estimates and that pricing information. So it's up. She put it up right now on the slide,
Yep.
but I will definitely send this. I'll send this out to everybody so that if you're interested in, hiring Sharon, you have all her information there. So
also, you've got my Twitter handle at the bottom there if you want to reach out to me that way. Feel free to link with me on LinkedIn as well. Love to talk with you further, and email is probably the quickest way if you have something specific or time sensitive. I want to thank Cozy for giving all of us the opportunity to talk together about this kind of stuff. I am very passionate about being proactive in business, whether it's legal, financial, whatever. And so the more tools you have in advance, the less you have to worry about it and the less money you spend over the long run. So I want to thank Adina for putting this together and Cozy as well for hosting us today.
And thank you, Sharon, for being a part of this. And with that, we conclude the webinar. The next one will be on May 31st, and that's about pricing for profits. And Marvin Montgomery will be leading up that webinar. All the login information is on our website, www.cozy.org/events, and you'll be able to register for that webinar on our website. Thank you so much for joining us, and thank you, Sharon, for your time.
Thanks, Adina. Good tribe.
Bye.